In modern law practice, how does a lawyer balance the time it takes to write really well against the reality of client demands to keep costs down?
A lawyer doesn't do it, is my experience. I have never felt comfortable standing up before a court, getting a question, and saying, my client didn't pay me enough to know the answer to that, Your Honor. Or writing a brief that some judge is going to put down and say, well, that's not very good, and have a little thing at the end saying, you know, this brief could have been a lot better if the client had only paid a couple $1,000s more. That's the difference between being a professional and not. I mean, you have an obligation as an officer of the court, and regardless of the financial realities, you're the one standing up there, not your client, and it's your name on the brief, and you've got to be comfortable that that's a fair reflection of how you want to be regarded as a lawyer. So I think every lawyer does it. I mean, if you have an obligation, you put in whatever's necessary to get it done, and then hope the client will pay for it.
But you're willing to eat some time if it saves your professional reputation?
I think you have to be. That's part of what it means to be an officer of the court. You're not just the client's representative. You're there to make sure the court has the information it needs to decide the case as well. And one thing I've learned in my short time as a judge is we really do depend on the lawyers, both in giving us straight answers and in presenting straight arguments in the brief. And a slipshod performance because, I only had so much money I could bill or afford to spend on this brief is a great disservice to the court.